Welcome to the latest of Family Law in Partnerships podcasts. So we're lucky to be joined on this occasion by Jeremy Johnson, who is one of New Zealand's leading barristers, described as in a league of his own. Jeremy's got expertise in all sorts of things: private wealth, equity and trusts, and high-value complex relationship, property and commercial law. Today, though, we're talking about divorce and separation and related financial claims. So welcome, Jeremy. I guess
David.
the first thing for us possibly to think about would be how we know whether proceedings can be taken in New Zealand. Can you tell us a little bit about that, both in relation to divorce and potentially financial claims?
Yeah. Look, more than happy to do that. I think it's probably becoming more relevant for New Zealand. Just to give us a little bit of a plug with our Golden Visa program, which some people watching and listening to this may be interested in.
Okay.
It makes it extremely easy if you invest into high growth assets, 5 million New Zealand dollars, so about 2.2, 2.3. Probably close to £2 million, then you get the right to buy a house in New Zealand that's worth more than $5 million.
Gosh.
No one else can really buy land here. And you also can apply for your residency, and you can apply for that having only spent 21 days in the country over about 3 years.
Gosh, amazing.
So anyway, look, when it comes to divorce, the critical issues, it is with everything in sort of cross-border law. Domicile is an important concept. I'm sure lots of people watching this will know what domicile is. So basically, if you were a New Zealand citizen at some point, either you were born here, or you lived here for a long time and intended to remain here indefinitely, and you go overseas, what we call our diaspora do. I think there's out of a country of 5 million.
A lot of New Zealanders in London, that's for sure.
A lot of New Zealanders in London. I think we have over 1 million New Zealanders who live offshore.
Gosh.
With only about 5 million of us here, if that gives you an idea. You can divorce in New Zealand, and by divorce in New Zealand, we talk about solution the marriage in the technical sense. Or alternatively, there is a residency.
Clear on that. Just to be clear on that, the domicile point, because you're right, I'm sure a lot of people will understand the concept, but it is a bit of an odd concept, isn't it? Do you look at domicile in the same way as English law, i.e. the country to which you have the closest connection? Rather than, because I think certainly I've dealt with other jurisdictions. I was dealing with a US state, I can't remember which one it was recently, where they were talking about residence and domicile, but they meant something completely different. I think from our perspectives, domicile, as I say, is that the country or jurisdiction to which you're most closely connected. And just so everyone understands, we all have a domicile of origin, which is usually where we're born, although it depends on the domicile of our parents. And that sticks with us unless we go somewhere else with the intention of remaining there indefinitely or permanently. So that's domicile, and that's both, I think, the same, sounds like it, from a New Zealand and an English law perspective.
Yeah, and so we have a Domicile Act, I think it's 1967, was the date of it, and it basically reflects the English position. So, to kind of give a practical example of this, I have been dealing recently with the separation of a couple. They are New Zealand citizens. Their domicile is New Zealand. They have moved to work overseas. They're in a country where their ability to get residency or citizenship is very limited. Therefore, their domicile remains in New Zealand. Because the other key point with domicile, of course, is once you have it at origin, you have to actually proactively change it in a sense.
Yes.
It's actually quite hard to change. So we basically do have the same concept of domicile. For divorces, we have a residency test as well. So if one of the parties is resident in New Zealand, habitually resident in New Zealand, then divorce is available.
Sounds very similar to the position in England and Wales, and we're very much, the jurisdiction is habitual residence, and there's different bases for doing that, or domicile. And I think domicile from, our systems clearly have a lot of similarities in this respect, at least, although some great differences that we're going to talk about. But I think other jurisdictions find it quite odd, don't they? Because we deal with a lot of divorces in England where people haven't lived here for a very long time. They've gone and lived as expats in another jurisdiction for, sometimes 10, 20 years. But because they say they intend to come back, then England remains their domicile. So it's an interesting concept, I think.
Yeah, it is. And the habitual residency test for divorces is kind of a little vague, but normally if you've been resident for more than a year,
Right.
and that's obviously still separate again from tax residency. and separate from domicile. When it comes to the division of property, we actually have we have an entirely separate act statute, and we have an entirely separate regime. But effectively, our act has jurisdiction if a number of conditions are fulfilled. So the first is our act applies to land in New Zealand, real property.
Right.
So if the asset in question is land, then our Property Relationships Act will apply, unless you can agree otherwise, but you probably want to agree while you're still, before you separate, rather than
Yes.
afterwards, as per usual. If one of the parties is domiciled in New Zealand, then our Act you'll have jurisdiction over real property in New Zealand. You kind of always want to say unreal property. That's not what we mean. But corporal property, shares, bank accounts, that sort
Yeah.
of stuff, chattels, etc.
Yeah.
Our Act will have jurisdiction over those assets both in New Zealand and overseas. So we have the immovable, movable distinction. And
Okay.
also if one party is resident in New Zealand at the time the application is filed.
Right.
So you can come here and for the purposes of kind of divorcing and dividing your assets if you wish.
As soon as you acquire residence, you can make a claim, can you?
Yeah, basically.
Interesting. Okay.
And you could conceivably do it post-separation as well, based on how
Yeah.
our Act is drafted. You can also, and I have seen this done, even if you're domiciled overseas, you can have New Zealand law apply to your assets by agreement.
Okay. In another jurisdiction, do you mean? Or
Yeah. So
Okay.
under New Zealand law, our Act says that two parties who live overseas could agree that our Act will apply to their assets.
Interesting. I see. So
Opt-in regime as well.
that's fascinating. And is it linked? Is it necessary to have a divorce in order to make the claim for property in New Zealand, or is that entirely separate?
Only in one respect, which I'm sure we'll talk about as we go. So we effectively have, so perhaps if we talk about divorce, so we start with that process.
Yeah.
New Zealand is no fault, like most places are these days. Been no fault for a very long period of time. But in order to have your marriage dissolved, you need to have been separated for 2 years.
Right.
So there's a 2-year wait until you can divorce. So the way we've dealt with that is our Property Relationships Act governs most of the matrimonial property, and that is available at any time post-separation.
Okay.
Right. So you can separate today and do your deal as to how you want to divide the assets tomorrow. That's fine. You can separate today. You can file in court tomorrow for division of property, which is the language we use. We talk about division of relationship property. So you don't need to wait for divorce. We have a separate claim that you can only bring against trusts, which is one of the more popular claims to bring these days. It's called a Section 182 claim under our Family Proceedings Act. And you need to have the marriage dissolved before you can bring that claim.
I see. Okay. Yep. But you could bring a property division claim without a divorce.
Yep. Absolutely.
That's very interesting. That's very different, again, to the position in England and Wales. The sort of gateway for us, as you probably know, is the divorce. So you have to get your divorce here. You don't have to finish it, but you have to start it. And ours, again, is a no-fault system, thankfully, at long last. So you have to start the divorce process, and then you can make a financial claim. And we don't have any relationship or any property dispute processes if you don't have a divorce. The only exception to that would be a claim for financial relief after an overseas divorce. So that's a claim where people have got divorced in another jurisdiction, but they haven't had any, or they haven't had sufficient financial provision in that jurisdiction, and they've got links to England and Wales. In those circumstances, they can make a claim here. But we certainly can't have property division separate to a divorce or a claim following an overseas divorce. So, that in that respect, it's quite different.
Yeah. And I suspect the reason for that relates to the other big difference between us, which is that our Property Relationships Act, at least, covers de facto couples.
Yes, which is absolutely completely different. I mean, that's one of the fascinating things, isn't it? Because as you will know, Jeremy, in England and Wales, we've had huge difficulty in getting any recognition, really, for people who live together who don't either marry or form a civil partnership. So there's been campaigns for years by all sorts of people, leading lawyers, lots of, politicians have been interested and talked about reform, but it has never happened. And there's still a huge backlash here when there is talk about reform, which I find completely fascinating, when in New Zealand and I think Australia as well, it seems to have gone through so easily. Have you got any sort of insights into why it's been so easy for you to do that and yet so hard in England?
That's a very good question. I mean, occurred in 2000. It was around the year 2000, I think it was legislated, and it came into force in about 2002. So our Act dates from 1976, and it was called the Matrimonial Property Act, or the Property Brackets Matrimonial Relationships Act. Now it's become the Property Relationships Act. So there was a change to the regime. Look, New Zealand's just a smaller country, so it's just one of those things where people probably are less interested in formal rules and a bit more interested in substance and justice than in other countries and parts of the world. And that's probably why, it's probably one reason. The lack of an established church probably has an influence as well. We have this very odd hangover in New Zealand. I mean, if you compare us to, say, France, we're close to England in this sense. So our Marriage Act still allows priests from certain religions, which are all listed in the schedule, to solemnise marriages on behalf of the state, which is obviously a carryover from the established nature of the church in England and our kind of colonial heritage. Whereas, France, obviously, the civil and the religious are completely separate, whereas we still mix them up a bit. And it was also, the legislation was actually done in a pretty bipartisan fashion, but it was also brought in at the same time in 2000, around that sort of early 2000s period, where the government introduced civil unions, which were available for same-sex couples. De facto rights were available for same-sex couples at that point in time as well.
Yeah, it's interesting because, of course, we now, of course, have equality for same-sex couples. We initially with civil partnership, then same-sex marriage. But cohabitation reform, for some reason, seems that step too far. It's desperately needed. It's desperately needed. We have people who have lived together for, many, many years. And if you look at the sort of traditional model, say you've got a woman who's given up work to look after children and therefore hasn't earned anything, then, at the end of that relationship, when the children are gone, she's got no financial claims at all, which I think is appalling. But there we are. There's a good court case, I think, for reform, but we'll leave that one perhaps to others and see what happens. But back to the Property Relations Act and how financial claims following separation are dealt with. What are the sort of principles upon which New Zealand operates in deciding how assets are divided up?
So the starting principle is you have three types of property. You have relationship property, separate property, and basically, third-party property, usually trust property.
Okay.
If it's relationship property, then it's 50-50. No questions asked. That just happens.
Interesting. Okay. Is that in the statute? Is that what the statute?
That's what the statute says. It's an equal division of relationship property. And relationship property is effectively income earned during the relationship, wages, salaries, that sort of thing. It is property acquired during the relationship, so long as it's not acquired with or in substitution for separate property. So, for example, if I go and buy a house today, then my husband has a claim to it. But if what I'm doing is selling a house I already owned before the relationship and I'm buying another house, that remains separate property. So there's that. The family home is an important one that's very relevant in New Zealand because most people's primary assets are their home. Yeah. So the family home is automatically relationship property regardless of whether it was owned by one party prior to the relationship.
Okay. Interesting. Yeah. Okay.
So and then family chattels are usually considered part of it as well. Cars, often paintings, that sort of thing. The separate property is everything that you own before the relationship and anything that flows from that separate property. So if you had a share portfolio before the relationship, the dividends from it are separate property, unless you intermingle it with relationship property. Okay. So, and inheritances count as separate property as do gifts and distributions from trusts. So the obvious, what often happens is, I get $100 from my parents as my inheritance. If I put it in our joint bank account,
then it becomes
relationship property.
Relationship property. So your husband then gets half of it.
Yeah, correct.
Okay. All right.
So, and lots of people kind of forget that. And then you have the trust property, and that's more, basically there's two primary claims that are brought against those. If you had a piece of property that, but for the trust or companies in some cases, it would have been relationship property, and you put it into that structure with the intention of ensuring it was not relationship property. And by intention, we mean not that you wanted to achieve that, but you knew that was the outcome. Okay. Then you can get that, you can claw that property back.
Right. Okay.
So that's what we call the Section 44 claim, and they're quite big in New Zealand. And then you have, particularly for trusts, what we call Section 44C claim, and that's even weirder, to be honest. if the trust owns a piece of property, but for the trust would have been relationship property, but there was no intention to defeat the interests, as we say. Yeah, you didn't put it in
Right.
there with the purpose of keeping it away from the relationship property pool. Then
Yeah.
you can still get an order that income be paid out to
Okay.
recognise the lack of relationship property.
Fascinating. Okay. And can you ever make a claim in relation to property that's entirely separate? Is there any basis to make a claim?
No,
Right.
people try.
Okay.
People try, including me. Not really. There's the odd sort of provision, like if you had separate property and then you were converted into other property for the purposes of supporting the relationship.
Yeah.
Yeah, but that claim there's never been a successful one of those. So there's the odd little bit in the act, but no, broadly speaking, if it's separate property, it's separate property. The trickier question, David, comes in cases where, there was a pre-existing company, the shares
Yes.
in the company were owned before the relationship. So there's separate property, and then say a house or a rental property was purchased into that company during the relationship.
Yeah.
Because
Right.
the ordinary thing is the piece of property you're concerned with is the shares, and they would be separate property.
Yeah.
Do you have a claim against the rental property going in? And the answer is under 44, yes, you would do.
I see. Fascinating. Okay. And is it possible to claim ongoing income from someone you've separated from by way of maintenance or something?
Yeah. So we have two different kind of claims available. You have what we call the spousal maintenance claim, which extends to de facto couples as well.
Right.
The approach in New Zealand is it's meant to be effectively a payment available for a party, for the non-earning party, to enable their lifestyle to gradually adjust to their new circumstances.
Okay.
So it's not permanent by any stretch.
Yeah.
It may award up to sort of 24 months.
Okay. So quite short, certainly from English standards.
Yeah, but it is quite short, countries' perspectives. But then that also doubles up with what we call the Section 15 claim,
Right.
which is under our Property Relationships Act.
Okay.
And that is what we call the economic disparity claim.
Okay.
So, for example, if my husband stayed at home to look after the cat or the children and the usual, most relationships, and at the end of it, I'm a barrister and he
big fortune, no doubt.
and he would have been, but he's not now, and all that.
Right.
So there's a big gap in earnings. Then we do this. Accountants do a spreadsheet calculation, and they figure out basically the value of the gap over a period of time, and then you discount it for real terms. You do a whole lot of things to it, and you get a figure. And then that's what we call the economic disparity claim. So in most cases, we have a spouse who has worked for most of the relationship, and the courts don't get into why. Like all the, let's be frank, often husbands who show up and say, "Oh, well, I wanted her to go back to work and she wouldn't." So on. The courts aren't. They're not interested. The assumption is it's the division of functions in the relationship. The fact somebody stayed behind, looked after the kids and looked after the house, that's all considered equal. But the end result is most cases you see in terms of settlements, the non-earning spouse probably gets 55 to 65% of the property pool.
Oh, I see. So they get more of the property to compensate for the...
Yeah. So it comes out of the 50-50 division gets adjusted to account for the economic disparity.
Okay. And a question, and I'll explain a little bit how things work in England in a moment, but because you're much more formulaic in New Zealand, although I hear very clearly there are issues that can be argued about, which is helpful if that's your job. But do cases fight, or does the formula enable people to see what the outcome is going to be and reach agreements easily?
It's a very good question. No, people do fight. I've had cases where they separated 7 years ago and you're only just doing the trial. It's been going a long time.
Wow. Okay.
Ordinarily, most of the cases that are fought about, there's usually something significant involved in terms of assets. But normally, the factors that lead to fighting are there was a prenup and somebody wants it set aside.
Okay.
Or alternatively, there's significant assets and trusts, often family money. And then you have the question of the application of either Section 44 is actually quite uncertain because those are deeply factual questions often. Who did what when? What was the intention? Or alternatively, you have what I mentioned, those 182 claims earlier. They are basically, the court says if you have a trust or assets in a trust that are a nuptial settlement, which means settled in contemplation of a particular marriage, and you divorce, then the court will assess, based in very high-level terms, the spouse who doesn't control the trust, what he or she would have got out of the trust if the marriage had survived. compared to what they'll get now, and then they do a
Right.
calculation. But it's a very broad discretion. So you
Okay.
can fight quite a lot about what a Section 182 claim will get you.
Yeah. So you do
Yeah.
have the discretion because, I mean, as you know, England is all about discretion, certainly in terms of family law. So we don't have a formula at all. And I have to say, if you look at the statute, you've really got no idea what the outcome's going to be. Yeah. And it's all come from case law over the years since our Matrimonial Causes Act 1973, which of course is quite old now. But in some respects, some bits of it are similar. It's say highly discretionary, so there's absolutely no formulas. But we have developed a system where assets are either categorized as matrimonial or non-matrimonial. It sounds in a similar respect to the way they are in New Zealand. So matrimonial property is everything that you build up during the course of the relationship, including pre-marriage cohabitation through work or business, through own endeavors. That's all matrimonial. Non-matrimonial property is, again, broadly speaking, things that you can have at the start or things that come in, again, from an external source, such as gift or inheritance. And that's non-matrimonial. You're entitled to share in the matrimonial property. There's no fixed shares, but your starting point is equality. And in many cases, that's the finishing point as well. There's no entitlement to share in non-matrimonial property, but it is possible to make a claim in relation to needs. So there are many cases. Needs is often the driving factor in England because, of course, most people don't have a surplus of assets. And in those circumstances, needs will always be given priority. And so even if all of the assets are non-matrimonial, claim can still be made in order to meet the other person's needs, which can include housing, all sorts of things. Interestingly, over the last few years, we've developed this concept of matrimonialization of assets, which is where non-matrimonial assets become matrimonial. And there was a recent Supreme Court decision, Standish, which tells us it's all about intention, what people intended. So, which we should talk briefly about pre and post nups in a moment, but just before perhaps we move to that, we also have spousal maintenance in England. It used to be the case that most of those orders would be what we call a joint lives basis, i.e. they'd last until the recipient remarried or the first person to die. Happily, that's changed. I don't think that was ever a good thing for people to link together for years and years after the marriage. So now maintenance is very much a needs-based assessment, and it's to enable the recipient to adjust without undue hardship. That's the term that's often used.
Yeah. Well, your comment before, because we have a key principle is the clean break principle.
Yeah, likewise.
Correct. So so often you don't usually see continued joint ownership of assets. The court strives to achieve an outcome where somebody's paying someone else some money, and someone's taking the house or the shares or whatever it is.
Interesting. Okay. And just before we wind up, I ought to ask you a little bit about what the position is with pre and post nups in New Zealand. Are they taken into account? What's the situation?
Yep. So prenups and postnups are both available under Section 21 and Section 21A handily for the postnups, if you want to find it in the Property Relationships Act. Prenups are very common here, as are postnups on the whole. We have a statutory ability to set them aside in cases of serious injustice.
Okay.
Serious injustice is measured in part by reference to the process, like was the process fair, did people receive independent advice, so on and so forth, and was there undue influence or duress, and that has to be a genuine kind of standard. The idea of he said he wouldn't marry me if I didn't sign.
Right.
That's not enough. It happens every time.
Yeah, quite.
Yeah. And then part of it looks to the substance, i.e. is this so different to what people would have got had the Act applied at the time of signing?
Right. Okay.
Yep.
And otherwise they're binding, is that right?
Absolutely binding.
Okay. Fascinating, because of course it's very different in England. We do a lot of pre and post nups, but technically they're not enforceable.
Yeah.
But of course they are taken into account, and courts are increasingly giving weight to pre and post nups. What's really important from our perspective is that everyone knows what they're doing, which usually means there has to be financial disclosure and legal advice. And really, really importantly, the agreement meets needs. And that's always the challenge, of course, when you're drafting a prenup in the early stages of a relationship, because you have to project forward to, okay, what is going to be necessary to meet needs if this couple have children, if they stay together for 20 years and one of them doesn't work, all these different scenarios, the agreement has to meet needs. So that's often a challenge in England, and there's been talk about bringing in enforceable pre and post nups. But I think we're so wedded to needs-based provision that I think it will be very difficult to have an agreement that didn't meet that.
Yeah, and I actually find the hardest ones, to be honest, for the prenups are those sort of the high net worth ones.
Yeah.
Because there's so much money to go around in a sense, but then you've got to say to yourself, well, if the total family is worth 100, and this kid's share is 25 or 33 or whatever, is it really fair to say that after X number of years of marriage, this person just gets a house and that's kind of it, right?
For sure. No, I agree. They are really, and particularly if it's money and expectation of money in the future. So, you can sometimes have a couple living quite modestly, but one of them knows they're going to be very, very rich at some point, and then it's thinking through what impact is that going to have on the relationship.
Yeah, correct.
But look, Jeremy, it's been fantastic to have you join us. Thank you so much. It's a really fascinating discussion. Well, at least I found it fascinating. I hope some of our viewers and listeners do as well. But thank you. It's been great to have you with us.
Thank you, David. Lovely talking as always.